Hi, my name's Danielle and this is Sumitra.
Hi.
Arjun.
Hello.
Christine.
Hello.
Michaela.
Hello.
And Ruth.
Hi.
We're all final year law students.
Hi, my name's Danielle and this is Sumitra.
At the University of Hertfordshire.
Arjun.
I'm going to talk to you today about your rights as a tenant in a evicted property. We'll cover tenancy deposit protection, tenancy agreements, evictions, landlord accreditation and guarantors, as well as giving you people to contact should you run into any trouble. So here is Sumitra to talk to you a bit about tenancy protections.
So, tenancy agreement. A tenancy agreement is a contract between a landlord and a tenant specifying the terms and conditions of their rental agreement. The most common type of tenancy agreement is the short-hold tenancy. The next slide, I'm going to talk about tenancy deposit scheme. TDS is a government-approved tenancy deposit protection scheme in England and Wales, operated by the Dispute Service Limited. The Housing Act 2004 requires landlords and letting agents to protect deposits on a short-hold tenancies in a scheme. It provides with the both insurance-backed and custodial tenancy deposit protection with free impartial dispute resolution for when disagreements arise over how the money is divided. Landlords are now legally required to safeguard their tenant deposits with three government-backed deposit protection schemes: Deposit Protection Service, My Deposits, and Tenancy Deposit Scheme. In the next slides, I'm going to talk about disputes and problems. TDP offers a free dispute resolution service if a tenant disagrees with the landlord about how much deposit should be returned. Tenant can raise a dispute to get their deposit back if they can't contact their landlord and their deposit is held by one of the approved TDP schemes, that is My Deposits, TDS, and Deposit Protection Service. The TDP scheme will refund the deposit if the dispute resolution service agrees. In the next slide, I'm going to talk about this deposit protection scheme. The tenant pays the landlord or letting agent their deposit. The landlord agent pays the deposit into the DPS within 30 days of receiving it. Following receipt of the DPS, will send a receipt confirming the deposit protection. The landlord agent gives the tenant the prescribed information, scheme, leaflet, and terms and conditions of the scheme. At the end of the tenancy, the landlord agent and the tenant agrees repayment of the deposit and inform the scheme administrators. If there is a dispute, the DPS administrators return any undisputed amount to the relevant party, but hold the disputed portion until the area service or the courts decide what is fair.
Eviction and tenancies. The process of removing someone from a property they are no longer entitled to comes to a landlord serving a notice, providing that they require the tenant to vacate the property. If this is done correctly, the tenant would be expected to leave the property. However, if a tenant does not leave the property after this process, a landlord can then apply to the court for possession of the property. An AST is a tenancy fixed period, which can, for example, last 6 months, where a tenant would normally pay rent every month for the agreed 6 months to live in the property. As a tenant, you have protection, meaning that you would be unlikely to be removed from the property during the agreed term. After the fixed term concludes, the tenant would become a periodic tenant, meaning the same terms and conditions would apply, but the tenant and/or landlord may serve notice on the other at any moment within the terms expressed in the tenancy agreement. Eviction process. During a Section 21 notice, a landlord would need to meet multiple terms of formalities in order to serve a Section 21 notice. These may include the service of how to rent guide, gas safety information, and the energy performance information. If a tenant is served a Section 21 notice, it does not mean that the tenant must immediately move out of the property if the landlord has not correctly completed the paperwork necessary for a Section 21 notice. Then it may be possible that a court would not grant possession if the tenant stayed in the property. It is important to note that just because as a tenant you have received a Section 21 notice from a landlord, that doesn't necessarily mean that you must immediately leave the property. Only the authority of the court can force a tenant to leave the property. A standard court possession order is not a normal order. There's a specified process for possession where the tenant has an AST and the landlord has served a valid Section 21 notice. This is commonly known as the accelerated procedure. During this process, an application is issued to the court and papers will be sent to the court, tenant, and landlord that would invite a tenant to respond to the application made by the landlord. A tenant can raise issue for a defense or even look to counterclaim if they choose, and if such method is appropriate. A court would aim to examine all documents and papers to make sure that they are correct. If they are not correct, then the court can dismiss the case or the judge can ask the case to be listed for a hearing. This method cannot be used for arrears or money judgment. However, if the judge has reviewed the paperwork after the tenant has had the chance to respond and all is correct, a date would be set where a tenant would have to leave the premises, an order for possession would be granted, the tenant would be obliged to pay for the rent up to the date for possession. It is important to note, a tenant can still remain in the property after the date for possession set by the court. Anyone who comes to the property to remove the tenant from the property at the stage would be doing so unlawfully. Only court bailiffs who have the power to do so can remove a tenant from the property lawfully. Once an application for a warrant has been made, there are normally 5 to 6 weeks from the date that the application was made to the point at which a warrant would be executed. At any point within those 5 to 6 weeks, a tenant would have the ability to apply to a court to prevent the eviction. Although, if an order for possession is made on mandatory grounds, then it is highly likely that the application for possession would be successful. Evictions and COVID-19. Currently, all possession cases in the court are suspended due to Corona. This includes all claims to be issued at the court. There are no hearings in relation to possession cases. There are no evictions taking place at present. The suspension of court activity for housing cases had started in March and will continue until the 25th of August 2020. It is estimated that the first hearings of court cases will be in mid-September, and that in September and October, hearings are likely to take place by telephone or video. A landlord is required to follow a court process in order to evict a tenant. Illegal eviction without the court bailiffs is a criminal offence. Landlords cannot force tenants to leave without a possession order and court bailiffs. The government has provided protection to tenants so that they will not lose their homes, although it is unlikely that this protection will continue beyond August 2020.
The partnership accreditation for landlords is a landlord and property accreditation scheme that aims to improve the standards of privately rented accommodation. The scheme was founded by Welwyn Hatfield and the University of Hertfordshire in 2012. Within 2 years, the scheme had accredited 54 landlords and 4 letting agents, and have since accredited many more. The scheme aims to recognise landlords that exceed property standards and meet the legal obligations that fall on property owners. Students are actively encouraged to seek landlords who have gained this accreditation, as they will have assurance that their new property will meet legal standards and can have confidence in a well-managed property. Students, and particularly international students with tricky language barriers, often fail to fully read and understand the tenancy agreements they're signing and can get themselves into bad situations. When disputes arise with a PAL accredited landlord or letting agent, PAL operates an independently managed complaints procedure that ensures quick resolutions to any issues. Non-PAL accredited landlords are not covered under this procedure, and therefore issues can get out of hand and be time-consuming and expensive. Some landlords may be gold standard, meaning they regularly go above and beyond expectations and can be trusted by people to provide exemplary service to their tenants. Any students who are unsure about who to rent from should contact PAL or visit their website for more information. Alternatively, our university's community liaison and support officer is there to help with any inquiries you might have.
First, I'm going to provide a little information about obtaining a guarantor. A guarantor is someone who agrees to pay your rent if you don't pay it. This could be, for example, a parent or a close relative. If you don't pay your landlord what you owe them, they can ask the guarantor to pay instead. If your guarantor doesn't pay, your landlord has the right to take them to court. Your landlord might want to check that your guarantor is able to pay the rent the same way they checked your ability to pay, and this could be done by a credit check. International students may not be able to obtain a UK-based guarantor. If you cannot obtain a guarantor, the landlord may ask that you pay rent money in advance. They may even ask you to pay a year's rent upfront. In this case, especially since you cannot view the place in advance, it's important that you consider choosing an accredited landlord. As Danielle mentioned, you could use PAL, which recognizes landlords that provide quality accommodation. You can view the list of these accredited landlords through Ask Hertz, or you can contact the university's Community Liaison and Support Officer. Their email address is community@hertz.ac.uk. They provide advice and support on private renting off campus. Support is also provided by the Students' Union Advice and Support Center. They have advisors that you can contact by phone or email. And it's also important to consider the fact that if you're renting a private flat with other housemates, you will be jointly and severally liable for any damages or unpaid rent. Now I'm going to discuss some of the different ways the university offers support for students living off campus. The Community Liaison and Support Officer provides support to students living off campus. So they provide assistance, advice for issues that may arise in the community. They can also refer students to relevant services or agencies for further assistance. They also investigate any breaches to the code of conduct by students. If there's a dispute with residents of the local community, then they are the first point of contact, and they work very closely with local statutory bodies such as the City Council and the police. As students living in private accommodation, you're part of the local community, and you should therefore consider the diverse range of cultures of those around you. There are many factors that contribute to a breakdown of neighborly relations, such as noise issues, inconsiderate parking, and even general tidiness of the property. And with these types of issues, the Students' Union Advice and Support Centers offers confidential and impartial advice. They can help you handle landlord and agent disputes. They can also facilitate informal mediations between housemates, or they can give you general advice while you're house hunting as well. So the university's dedicated police team communicates with the university, and they are the first point of contact for university students. We have 3 police community support officers that are funded by the university. They patrol the campus and the off-campus properties as well. They communicate with the dean of students, and they highlight which students have maybe been victims of crime, have perhaps committed an offense, or have witnessed a crime. These officers encourage problem-solving techniques, and they're very community-oriented. Along with keeping the community safe, their goal is to empower victims and help identify what additional support students may need, such as financial hardship, well-being support, mental health, or addiction. And then they work together with the university to try and meet these needs, either through resources from the school or other local organizations. If there's ever an urgent matter, you're still encouraged to call 999 or 101 for non-emergencies. However, you can always email these officers as well if you're a victim of a crime or if you witnessed a crime. In the event that there's a complaint, such as noise, for example, they visit the student together with the school's community liaison and support officer, and they try and resolve the dispute amicably first. The officers also go door to door from time to time to offer burglary advice and just to remind students to always keep their doors locked. So these are just some of the different ways that they use community policing to proactively address safety issues. To connect with the police team, you can follow them on Instagram or Twitter, and that's @HertzUniPolice. They also have a room upstairs in the Oval where you can find more information, or you can email them directly. In terms of victim support, the police team or the university may refer you to Beacon Victim Care Center. They offer a wide range of support, including bullying, physical assault, or hate crimes. Or you may also be referred to SARC, which is a sexual assault referral center, and they provide advice, information, and support for anyone that's affected by domestic abuse or is a victim of sexual assault. If needed, all of the contact information that I mentioned is also available on Ask Hertz.
We're very lucky as a university to work alongside Shelter. This year they launched a programme called the Court Desk Volunteer Scheme, and I have been taking part with the wonderful Ruth Camp, a solicitor, who is based out of Slough in Shelter. Shelter is a charity that helps millions of people each year. They started campaigning in 1966, and there's never really been any hurdle too high. they campaign to make sure that one day, ultimately, none of us will be homeless. Shelter helps all of those in need. So whether you're a student or you're not, if you're just working a normal job and you've hit hard times, you can always reach out to Shelter and they will be there to give you advice. So Shelter's website is a really good resource for a lot of matters that are currently affecting students, especially with the global pandemic going on. So they can help you to find suitable accommodation. They can also recommend finding a guarantor. They will help you to understand your tenancy agreement and other factors within this. So the next section of our little presentation is going to be a Q&A with the solicitor that I previously mentioned. So move on to the Q&A. So first of all, I just want to ask Ruth to introduce herself and what her role at Shelter is, and a little bit about what she does.
Hi, good afternoon everyone. So my name's Ruth Camp, I'm a solicitor with Shelter. I've worked with Shelter for the last year or so, but I've had 15 years qualified as a solicitor. The work that I do is primarily at the moment working at the county courts, helping people who have eviction problems. So people who come to the courts who haven't come and had any assistance prior to the hearing and who need some help and support for what's going on there to understand the process, what's going to happen in the courts, what their next steps are and how they go forward. My job is reflective of what Shelter does nationally. We do this up and down the country, and we're there to help and support people. The court runner scheme that we've devised this year has been a great help to us in terms of being able to see people, to get more people through and support, and for the students to understand the process of how it goes forward. So it's been a great partnership, and we're hoping to continue that in the years to come when the world reaches some kind of normality.
Well, we have previously sent Ruth some questions that we know that our students are looking to get answers for. So the first one kind of reminds me of when you take out like a mobile phone contract. We're always told, read the fine print, but to be honest, none of us ever usually do. And it's certainly something I wouldn't have done before my law degree, if I'm being honest. So when we're thinking about our tenancy, how important is it for us to read our tenancy agreement?
Okay, so you would expect a lawyer to say it's very important to read a contract, and I appreciate that it's incredibly dull to sit and read through a tenancy agreement before you sign on the dotted line. But I can't underestimate how important it is to do that. So you know the things that you're responsible for, and you know the things that your landlord's responsible for. Now, very often these feel like standard agreements, but if you have a private landlord who isn't going through the PAL system, or has only got one or two properties, doesn't want to do it sort of too complicated, you don't quite know what sort of curveballs they've thrown into the tenancy agreements. Some tenancy agreements have an awful lot of clauses that the tenant has to abide by. I read one recently that had 68 items for the tenants to be responsible for, and about, by contrast, 10 for the landlord. It's just really important you know what those clauses say, how they impact on you, and the things that you may end up being liable for, because it is the governance of your relationship with your landlord. It underpins everything.
If you can think about, obviously, the formation of this tenancy agreement, if, say, lazy students like myself don't want to read the whole thing, what would be the most important things you would tell us to make sure you've read?
Read the whole thing. Okay, so the thing that's really important, check who the parties are. Who is the landlord? Who are you actually contracting with? It should be the landlord's name and details on your tenancy agreement. Sometimes it's not, but you need to understand who it is that you're dealing with. Who is the other half of the contract, if you like. The amount of the rent, it seems obvious. Is the amount of the rent the same as what you agreed, the price that's on the contract? It needs to be the same. Are the provisions the same? You said 6 months. Is it 6 months? Is it, say, 12 months? How long is that contract locking you in for? What fees are being attempted to be charged to you? In 2019, the Tenancy Fees Act came in. I think it's 2019, I could be wrong. The sun has got to my head. But that has provisions for what fees can and cannot be charged to tenants. So you need to make sure that it's clear what they're trying to charge you for. And like I said, the responsibility for who has charge of what, because if there are 68 items that you may be responsible for under the list of tenants' responsibilities, you want to have a fairly good idea of what those say so that you know where your responsibilities stop and where the landlord's starts. It may not be that all of those clauses are fair, you may still have an argument to make about them, but you want to know what they say from the start, and actually the best time to negotiate those is before you've signed on the dotted line.
It's spoken our presentation about getting an accredited landlord. What would you say that the main differences are between an accredited landlord? Why is this so important that we try and find an accredited landlord?
The accredited landlord is a great scheme. It's designed to give you a bit of confidence that your landlord knows what they're doing, that they act properly, that they're not cutting corners, and that they're acting lawfully and in your interest as well as theirs. In practice, I mean, you could say that there's not much difference between an accredited landlord and a non-accredited landlord. Your landlord has paid to be accredited. That means that they should take some pride in what they're doing. A court's not going to consider whether there's any difference between an accredited or a non-accredited landlord, but from your point of view as a tenant, at least if you know that the landlord's put some extra effort and gone above and beyond, that gives you a little bit of comfort that they may be better from your point of view.
Okay, and we spoke about this in my presentation, but what is an actual joint tenancy for people that may have never read a tenancy agreement, or this is the first time that they're living away from home?
Okay, so a joint tenancy is where you have two tenants, two people's name on the tenancy agreement, who are the people who are living in the property. It could be two, it could be four. That they are the people whose name is on the contract, who have a responsibility for the rent and all the rights and obligations that go under the tenancy agreement. They are considered to be what's called jointly and severably liable for all the terms in the contract, which means that if one of them pays the rent, if one of them doesn't pay the rent, the other one is then responsible for the rent. They all have a responsibility under the contract for all the terms that are in it.
Okay, so what happens if, say, in my first week at university, I meet somebody, I think they're a very trustworthy person, and we sign a joint tenancy, and then suddenly they decide to up and leave? Where does that leave me?
Well, and we've all heard about those situations, so certainly know that that's been happening since the dawn of time. Let's put this bluntly, I'm afraid. The tenancy is your agreement with the landlord. It's also that person who has left agreement with the landlord. They are still legally responsible for that tenancy and for all the obligations met under that tenancy from the day that it's signed until the end of the contract. Whether they live in it or not, that's still their responsibility. So from the point of view of someone who's leaving a property, they might want to talk to a landlord about whether they can take their name off it so they no longer have a responsibility to pay rent. From the point of view of anyone living in the property, they need to know that actually, legally, it's not only their responsibility to pay the half of the rent they were going to pay, but if the student disappears off to a place where they are unreachable, then it becomes the responsibility of the present tenant who's occupying the property to pay that rent. I'm sorry, that's probably not the best news for the person who's staying in the home, but that's where it is. Best thing to do is to talk to the landlord. It may be that someone can be got in to move to join the tenancy and that their name can be added to the tenancy. That's your best outcome, but the landlord's not obliged to change the names.
In a joint tenancy, what am I actually responsible for? So it kind of sounds like there's a lot, which there is, but if I never had one before, what am I responsible for ensuring that I do?
In a joint tenancy, you are responsible for everything because you would be in a sole tenancy. We use the word jointly and severably liable. It's a bit of a lawyer term, and I appreciate that it's not always the most accessible. But it basically means that the two people who enter into that contract as tenants are responsible by themselves and together. So if you've got two people, Anne and Bill, who move in, Anne has disappeared but Bill's there. Bill has a responsibility to pay the rent in full, whether or not Anne does or not. And if the landlord can get hold of money from Anne, then he can't then chase it from Bill. you are responsible for it all in total between you, either by yourselves or as a partnership.
We often hear this term guarantor thrown around a lot. A lot of people are wanting to know, what is a guarantor, and do I actually need to have a guarantor? Can I just have a property that I pay in every month and I don't need to have somebody in my corner?
The guarantor is in a sense up to the landlord. What most landlords will do is carry out a credit check of their tenants. They will assess their ability to pay. And in the case of most students, you haven't really had the time paying as a grown-up. I don't mean that patronising, but most students don't have the credit history to be able to say, look, I'm going to be good for the money, and you don't have to go and ask anybody else for it. So a guarantor is what a landlord will often request if they don't think there's enough credit history to be able to be sure that the rent will be paid. And the guarantor is the person who steps into the shoes of the tenant purely from the point of view of paying the rent. They're said to stand as surety. A guarantor must be 18 years old at least. They don't have to be related to the tenant, but they can be. A landlord will tell you if they want a guarantor, and they'll give you the information that they need. Some landlords will accept that if you've got a year-long contract, to pay the full year up front instead of a guarantor. So it's about a discussion and a negotiation as to what the landlords will accept as to what's needed in terms of that entering into the contract together.
So if I move into my home, and the landlord is asking me for a security deposit, what does that cover?
Okay, so your deposit is money that you give to the landlord up front at the start of the tenancy, and it's money that's sort of designed to cover any damage that's caused at the property by the end of the tenancy. It's almost like an insurance policy for the landlord. Typically it's 4 or 5 weeks rent. It can't be more than 5 weeks rent because of the changes in the law recently. So it's 4 or 5 weeks rent. You pay to the landlord. The landlord has to, by law, protect that money. He can't simply leave it in his bank account and watch the interest grow, or go and take it to the horses and gamble it away. The landlord is required legally to keep that money safe in a tenancy deposit scheme. They have to give you information from one of the 3 accredited schemes, which is, as it was explained in our earlier presentation. They have to send that information to you. We call it as lawyers the prescribed information. That prescribed information has to be given to every single tenant on this contract to say, this is where your tenancy is protected, this is the number where it can be found at. You can check the information online that says that it's protected and that it's kept safe until the end of the tenancy. So it's there throughout. It's not supposed to be spent or set off against rent until the end of the contract and the matter is all finished. If at the end of the tenancy you have kept the house beautifully, you've watered all the roses, you've cut the grass, you've cleaned the windows throughout, and the kitchen is sparkling and spotless, there's no reason why you shouldn't get every penny of your deposit back. It's not always that way, unfortunately, and quite often you'll find that the landlord has gripes about whether it's been left in a clean state, whether there's been damage caused to the property, and there's a whole heap of disputes about whether there's reasonable wear and tear to a property, or what the element of damage is and who's responsible for that. So the point of the money being protected in that insurance scheme, the idea of the tenancy deposit schemes, it means that at the end of the tenancy, when you move out, there's a bit like a third person who's going to decide whether the money that is taken is fair or not. So if your landlord says, well, actually, I had to spend at least £1,000 cleaning your property, and you sat there going, you are really having a laugh, then the arbitration system is there to try and help to protect both sides. If the landlord really did spend £1,000 on cleaning, then there'll be some receipts and there'll be some evidence of that. But if that's just clearly fictitious, then there won't be evidence to support it, and the arbitration scheme should come down on the side of the tenant to say, well, this was unreasonable, and the amount of the money that should be taken is X or is Y.
If I felt like my landlord has taken money from my deposit, unfairly. Is that a legal thing that he can do, and what would I be able to do in order to get the money back?
So the idea is with the scheme is that the landlord will tell you what they propose to take out of the damage, out of your deposit, and you have an opportunity to respond to that. And if there's a dispute, then the scheme will hold on to the disputed money until that dispute is resolved. So it shouldn't ever be the case that you feel like your landlord's unlawfully holding on to money, because actually either you accept that the money that's being taken is reasonable, or you don't, and there's going to be a resolution to that. So I think it's, from a tenant's point of view, it's always about making sure you have the evidence. If your point of view is that you left the house spotless and it's, we painted it all and it was beautiful and it never looked cleaner, then you can take photos and you've got evidence. And actually, when it comes to someone arbitrating the matter, they've got a whole different set of paperwork in front of them that they can help to make the decisions that you need to make.
Okay, so often, as we know, things do get destroyed over time, and there can often be issues in property, such as maybe mold, which is caused by damp. If that was caused in that way, how would we prove that perhaps it's because we didn't air the place out, the windows, or if it was just maybe lacking insulation? When it comes to that kind of area of disrepair, what would you advise students to do?
Okay, disrepair is one of those things that comes up all the time with rental properties, and it's because you live in your home and not the landlord. The landlord doesn't see what goes on every day and all the time, and the care that you treat your homes with. The best thing to do is, when you have an issue that arises, you've spotted some mould or you've spotted some damp or you've got a window that's broken, is to report that to the landlord, to keep on reporting that, and probably do it by email or by some kind of message that you can record and say, look, here's the evidence of me reporting it to you, and give the landlord every opportunity to make repairs or to address the problem. Because if you've got to the end of the tenancy and your property is now covered in black spot mould and you never told the landlord about it, then the landlord's going to say, well, you've caused this because of X, Y, or Z. You've not opened the windows, you've not ventilated it properly, you've not treated it in a tenant-like manner, and therein lies a big long dispute. Whereas if you try and tackle it from the start, when it becomes a problem, then in the best case scenario, you're getting the problem sorted because the landlord's going to take it seriously and realises there's an issue that needs to be addressed. Or in the worst case scenario, you're going to go into a disputes zone, but you've got evidence that shows that you've reported it to the landlord and you've given the landlord every opportunity to try and sort out the problems. So for that reason, it's always best to try and sort out these problems as they happen rather than as they get worse.
Okay, so what are repair and maintenance charges, and when can a landlord submit them to you, and how do we understand the invoices that we're given if it's using very technical languages?
Okay, so the landlord should be responsible for repairs in the property. Under Section 11 of the Landlord and Tenants Act, they're responsible to keep the property in repair, and there are certain provisions within that they are required to meet. So if you're getting repair and maintenance charges, you need to be really clear as to what those are and whether they are actually your responsibility to pay those, because it may be that they are the landlord's to pay and not yours. So you need to go back to the tenancy agreement, you need to look at what the tenancy agreement says, you need to think carefully about what these things relate to, and ultimately, if you've been hit with an invoice that you just don't understand and it's got information that doesn't make sense to you, the best thing you can do is to contact the landlord and say, well, hang on, what is this and why is that my responsibility? Because the landlord is in charge of the property. There may be an element if you have caused some damage that there's some wear and tear, or it may be that something has accidentally happened that is your responsibility, but equally there may be insurance to cover that. So I think before you pay any maintenance, repair and management charges and invoices, be sure to understand what they are so that you can think about whether that's your responsibility.
Okay, so what is an inventory when we enter the property? And why is it important that we record like a detailed inventory of any items within the house?
Okay, so an inventory is a document that's usually separate to the tenancy agreement. It normally would have a list of the rooms in the tenancy. It would normally then take each of those rooms item by item to consider the condition that those things are in. So it may be as detailed as to consider the condition of the windows, the condition of the walls and the ceiling, and the doors. So it would consider whether there are scratches, whether there are dents. And you're supposed to go around at the start of the tenancy to look at that. It would also look at obviously all the things that are within it. So there may be curtains, there may be curtain poles, there may be fridges and cookers and things. So looking at the conditions of those at the start of the tenancy, and you're required to usually enter that inventory to sign to say yes, you agree with the description that's there. But then usually you do that again at the end of the process to again consider the condition and whether that condition has changed substantively through your tenancy, and if so, what's the causation to that? Is that likely to be just because it's in a place where it might get damaged, or is that because you've mistreated an item? And the point of the inventory is it helps to inform whether any money should be taken from the deposit, or whether there's anything that's related to the use of the property by the tenant.
This next question is a little bit more to do with present times. So what can we do if we can't afford our rent? So as we know, with everything with the pandemic, lots of people have lost their jobs. A lot of students were not able to claim the other sort of provisions like universal credit. A lot of us work on bank support, so we don't have a contract, so we can't get statutory sick pay. So what should we do if we cannot afford the rent?
It's an impossibly tricky situation that we all find ourselves in. These are unprecedented times, and I know those are overstated words that we all keep on using, but it's very clear that this is a situation that none of us have ever found ourselves in, and which none of us would want to find ourselves in, to be frank. As students, it's difficult because very often the money that you get by any kind of loan is then going to likely to discount you to any entitlement to welfare benefits like universal credit. It is, however, always worth checking that. It's always worth getting some advice to see whether, if your money has suddenly stopped for whatever reason, or you've stopped doing other extra jobs that you were doing to supplement your income to make that work, that you go to check universal credit to see if there's any possibility that you may be entitled to something that you didn't think you were. Because I always take the mantra that if you don't ask, you don't know the answer. So ask the question, check whether you're entitled, and you may be happily surprised that you are, but if you're not, at least you know that. Then there's other things to think about. Is there any possibility that in the extreme circumstances you find yourself in, that the landlord could look at any kind of rent reduction? Landlords aren't all complete ogres. They aren't all monsters. They all are usually human too. And they have a responsibility to their tenants. They may be more interested in keeping their tenants and keeping some income than maximising that income. Because if they are trying to make sure that they are getting the most they can get for the property, but actually the reality is you've got to move out, then they're not getting as much for that in total, because people aren't moving right now in the same way. And particularly in student accommodation, where it's possible that there may be fewer people looking for accommodation, then there will be more surplus housing, which is never good for a landlord who wants to pay his mortgage. So check whether there's any possibility of a rent reduction. See if there's any other way of getting support, or any other way of increasing the number of pupils in a property. If you have an extra tenant come in, for example, there's more of you to share the burden of the rent, so that may ease things. It may be that you have family members who can help or support. And I guess the last thing I'd suggest is the university has a great infrastructure for supporting their students, and the local authority has a role to play in this as well. It's worth talking to organisations like the university, their helping liaison scheme, like the local authorities, to see what they can do to help and support you, because actually local authorities have a responsibility to try and prevent homelessness, and it may well be that their intervention on a case might help to persuade a landlord to be a little bit more generous than they might otherwise be. So I guess the thing is to not sit on it, because if you sit on the point that you can't pay your rent, then the reality of that is that you're likely to then face eviction process. And whilst for the moment things have been static on evictions because there has been a stop in the court system, that's not going to last forever. And the reality is that sooner or later those will catch up, and that process will start up again.
So, like you said, these times aren't going to last forever, and even though that, like you said, it's been pretty static about evicting people. Say next year, hopefully everything's back to normal. What can we do if our landlord asks us to leave?
So as I think it's Arjun explained earlier in this talk, the landlord asking you to leave is the very first step in a process. And for many of you guys as students, you will be assured short hold tenants, and the landlord has to get the notice right. There's lots of things he has to have done, including making sure that the tenancy was started up in the right way with the right information given, the how to rent guide, the gas safety checks done, the electric tests done, energy performance certificates. And then at the point that he serves notice on you, he needs to make sure that he's done that at the right time, that you're not in your secure part of your tenancy, that it is a valid notice. So when the landlord asks you to leave, the very first thing you need to do is to ask yourself, is he doing this process properly? If he's just written you a letter and said, actually, I think I'd quite like my property back, that's not a valid notice. So you need to check the process, and that's that first, and that's really the very first thing to do. Talk to the landlord. You know, there may be something that could be done that can change the situation. That there may be misinformation the landlord has. He may be able to change his mind. You don't really know what's going on with the landlord until you have that conversation. If you think the notice is wrong, you can reach out and get help. You know, be that from Shelter, be that from any other organisation, get some advice on the notice. Once the courts start back up, a valid notice will then be issued at court, and the process of the accelerated procedure gone through, in which the landlord will apply to get possession. And if his papers are in order, then the possession will be granted, and the bailiffs come in due course. But it is a process. You need to understand that it doesn't happen from the moment the landlord says, I'd like you to leave, to you being forced to move. So there may be more time in the process than you think, so keep calm.
Well, we often hear these kind of horror stories of the landlord coming knocking and tells everyone to get out. And I think for a lot of students, we're not really aware of our rights around that. So we think that's a perfectly fair thing to do. So if it is like an unlawful eviction, or we feel it's an unlawful eviction, who can we contact if we believe that our landlord has acted unlawfully?
Okay, so the thing to remind everyone here again is the same thing that we've said before. The only person with the power or the authority to move you from your home is the court bailiffs. And right now the court bailiffs are not working. So if someone comes to your door right now and says, that's it, you've got to leave, and you feel intimidated to do that, that is an unlawful eviction, and that's a criminal offence for which you can contact the police and say, this is my tenancy, this is my home, they are making me leave. And you can reach out to get the immediate help there with the police. But equally, then there's a civil offence that you can claim compensation for. The thing that's important is to effectively stand your ground. If you think that the landlord is coming to remove you and he has no possession order, he has no right to do that, then call the police. You know, let them help to arbitrate the matter, because it's not yours to risk getting harmed or any injury, because that's not right. If you think that the process has gone through and you've been removed from your home unlawfully, you can still contact lawyers for help and assistance. Shelter do this, but other lawyers around who do all sorts of housing work will help and support that too. Or even Citizens Advice, they can tell you whether you've been unlawfully evicted. And they can tell you what support you might need and help to deal with that. As I say, it's a criminal action, but equally there's a civil application that can be made for damages, for compensation for that. So don't just sit on it, don't sit in silence, because that's not right.
actually summed this up quite nicely earlier on, but if we need legal advice, where can we go? What would you suggest to do if we need any form of legal advice warranted, especially accommodation or housing?
Okay, so I guess obviously I can plug the work of Shelter at this point, and you'd probably be surprised if I didn't. We are here as a national advice charity. Our telephone number is on our website. Our website is very accessible, and there's web chat, and there's all sorts of methods in which you can get help. If you just Google Shelter, you'll find us. We are, as I say, a national advice charity. We have lawyers who work up and down the country. We have advisors who have very high levels of training on housing law. So we can help and support you in as big or a little way as you need. More locally, as I've said, citizens' advice are always worth a call, because you can see someone face to face, or you can not under normal times when we're not in lockdown. And they have advisors who you can actually engage with, because you can see them on a face-to-face basis and understand if there's any issues. The other thing is of course, the university has housing support, and that information that was run through earlier by, I think it was Christine, has information about how you can get help. That's not always legal help. I think it's mostly practical help, but certainly they can point you in the directions of people who can legally help. You may be entitled to legal aid. Some people are, some people aren't. It does still exist, contrary to popular belief, and it definitely does still exist for housing cases. So it's always worth considering, well, actually, am I entitled to legal aid? Can I get a lawyer to help me act on this case? And that may be your best action. So if you go to community legal aid on the internet, you'll find information about checking your eligibility. There's a firm solicitors in Watford, I think, is the closest one, who deals with legal aid. But there are loads of legal aid lawyers in London who can help and support on cases that you may end up finding yourself with. But I think the biggest thing I have to say is worthwhile getting help as soon as you find you have the problem, rather than sitting on it, because sitting on a problem never solves it. And it always sees that situation escalates to a point where it's much harder to solve, and it's much easier to solve problems from the outset once you've got wind of it being a problem.
We've had a few questions popped up on the YouTube live chat. So the first one is just asking about eviction fees, which obviously we're not really going to know the exact answers for, but we have given all of the information. This presentation will be staying on our YouTube channel for the university, so you can contact the Liaison and the Health Commission. Somebody has asked that if you're an international student, is there any limit on how far you can live from the university? As far as I know, there isn't, but I'm not sure, Ruth, if you have any ideas.
So how far an international student can live from the university?
Yeah.
I doubt there's any limit, but it's always worth talking to your tutors or your department to see if there's anything. If you're planning on living in Scotland, for example, going to the University of Hertfordshire, that might be a problem. I think it's just you need to consider your own practicalities of where it's reasonable for you to live.
One of the questions was, how common is it for a landlord to rent a room without a contract agreement? And how concerned should a tenant be if I have a landlord that doesn't provide an agreement after moving?
Oh, I'm sorry, my internet's a bit patchy there. Can you repeat those two?
Yeah, that was, so how common is it for a landlord to rent a room without a contract? And how concerned should a tenant be if a landlord doesn't provide an agreement after moving in?
Okay. How common is it to rent a room with no contract? It's really not an ideal situation. I guess the question is whether you are effectively a lodger, whether the landlord is living in the same building that you're living in. Because if you are living in the same building as your landlord, you're not an assured short-hold tenant, you become a licensee, and your rights are slightly weaker. It's not that it's uncommon, it is certainly common, and it happens quite a lot in London, because the accommodation is so expensive and people are trying to get extra people living in their homes. I think it's just preferable, though, if you can speak to your landlord and at least get something in writing that says that you have a right to live where you're living. It may not be an assured short-hold tenancy, but at least if it's something that gives you a bit of confirmation that it is your home, that would be better than having nothing. And the second one is how frequent is it to, is it something about a tenancy with no agreement?
Yeah, so how concerned should a tenant be if their landlord doesn't provide them with that agreement?
Okay. The problem is if you are a tenant in a property without an agreement, it's very difficult legally to characterise your tenancy. Are you someone who is, as I've said, a lodger where you're a licensee, or if you have a right to occupy the whole property, what proves that you have that right? Now, if you have moved in and your landlord has said, look, this is all yours for 6 months or whatever, and you're paying rent week to week to week, you would have some basic protection. But what would happen in a legal setting would be that as lawyers, we would have to try and think through what are the characteristics of this tenancy. Do you have what we call exclusive possession? Are you there by yourselves? Do you pay rent or something like rent? Is there anything that's akin to a fixed period? And then there are basic protections that come into any tenancy. So the right of quiet enjoyment, the right to have repairs done, and the basic that it should be fit for human habitation. So those are all implied into every tenancy agreement. So you can have a situation where it's oral. However, it is always best to have those rights characterised in writing, because at least then you understand them. In the absence of having any information, then it's very difficult to get those rights characterised and to understand where your rights and responsibilities are in relation to it. So my best advice would be to go back and say, look, thank you for letting your home to me. That's brilliant. Can I have a contract that reflects what's happening here, please?
So we're coming to the end here. I've just got 10 tips that we have created as a group. So I'm going to go through them, and if you want to give any responses to them as to how important they are, feel free. So the first one is what we've been talking about, so the inventory. Make sure that you have detailed everything in the house. This is so important in case of any issues with disrepair, and if there's any furniture that's been provided, because sometimes furniture is left over from previous tenants. And one that Ruth has spoken about there, which is very important. So check that you've been provided with all of the necessary certificates. So if it's a gas safety certificate, or if it's is it the right to buy, or no, sorry, wrong scheme. But sort of there is documents that's given to you at the start of your tenancy. So what would be the main ones that we need to look for?
You need to make sure that you have your how to rent booklet, that's given to you in paper, that you have your gas safety certificate, there may be some energy performance testing information too, which is about the how eco-friendly your house is, maybe some electrical information testing booklets and things as well. So those are the main things to look for at the start.
So we've also said complete your own safety check. So while you're there, make sure the alarms are working, make sure that all of the locks work in the house, because often, you know, a key gets broken and it's very important for your own safety. We've spoke about this when we were talking about joint tenants, but try your best to only live with people that you know and that you trust and that aren't going to sort of leave you stranded, having to pay all the rent yourself. And one thing that Ruth also spoke about was about taking photographs of the home. So everything that happens, we're all very lucky that we've all basically walked around with a phone 95% of the time. Take a picture. If anything is wrong, make sure that you're documenting it.
It's really boring to do, but at the start of your tenancy, go around and take photos. Take photos of the walls, take photos of the windows, take photos of the floor. It doesn't really matter if you have 100 pictures on your phone of photos of a tenancy that you're going to live in for a year. But do you know what? Better that you take those than you don't, because if you don't have that evidence to fall back and rely on.
And that kind of ties into looking for signs of disrepair. So if there is anything wrong with the property, it's important to note that as soon as you move in, and to try and raise that with the landlord. We've also spoken a lot about getting a guarantor, but make sure you get the right guarantor for you. And even if it does take a little while, I think generally, Ruth will also say, it definitely pays off to get a good guarantor. And also, as Ruth has repeated many times, always read your tenancy agreement. It might be boring, it might have a lot of words that you don't understand, but it's important that we read it so we know what we're getting ourselves into. And ensure that as soon as you're there, if there is anything wrong that needs to be repaired, get your landlord to sign a written statement saying that they will make sure that the home is repaired to satisfactory standards before you move in. And please don't get any accommodation that you can't afford. A lot of people enter into these tenancy agreements thinking, I'll have a part-time job while I'm at uni, so I'm going to upgrade to the studio. But, you know, just make sure that you're being very, very practical about where you're moving. And that is our presentation. So we all really hope that you liked it. We've been working now for the last 6 weeks at just coming up with some of these tips. And I'm the last member of my team still in the chat. So I just wanted to say a massive, massive thank you to Ruth for being involved in this project. It's been so good having her help and her support, letting us know all of the law that we need to. It's not something that is taught in law school very often, so it's nice to hear it. We also
You're absolutely welcome.
Thank you. We also wanted to say a thank you to Jack for helping us with all of the marketing that we needed. I would never have been able to have done this if he didn't help us with all the technology. And a big thank you to Diana for running this legal clinic and letting us get to have the chance to talk to more students about this. So the link will be live after this. It will be stored on the YouTube channel and on our StreetLaw website. So thank you, everybody.